presented his report. I told Bob that I was not interested in putting out summaries, and I wasn't going to put out the report piecemeal. I wanted to get the whole report out, and I thought summaries, by very definition, regardless of who prepared them, would be under-inclusive, and we'd have sort of a series of different debates and public discord over each tranche of information that went out, and I wanted to get everything out at once, and we should start working on that. And so the following day I put out a letter explaining the process we were following and stressing that the March 24th letter was not a summary of the report, but a statement of the principal conclusions, and that people would be able to see Bob Mueller's entire thinking when the report was made public. So I'll end my statement there, Mr. Chairman, and glad to take any questions.
Thank you very much. As to the actual report itself, was there ever an occasion where you wanted something was redacted from the report that Mr. Mueller objected to?
I wouldn't say objected to. My understanding is the categories were defined by me and the deputy. I don't think that I have no. I don't believe.
Did you work with him to redact the report?
Right. Those categories were executed by DOJ lawyers working with his lawyers. I think there were maybe a few judgment calls, very few, as to whether or not something as a prudential matter should be treated as a reputational interest or something. So there may have been some occasions of that, but as far as I
understand it, you did not want to hurt somebody's reputation unless it really affected the outcome. Is that correct?
Right.
So was there any disagreement about 6E material?
Not that I'm aware of.
Any disagreement about classified information?
Not that I'm aware of.
Okay. So the conclusions in your 4-page summary, you think, accurately reflect his bottom line on collusion. Is that correct?
Yes.
And you can read it for yourself if you got any doubt. As to obstruction of justice, were you surprised he was going to let you decide?
Yes, I was surprised. I think the function he was carrying out, the investigative and prosecutive function, is performed for the purpose of making that.
How many people did he actually indict? Do you know?
I can't remember off the top of my head.
It was a lot.
Yeah.
So he actually has the ability to indict if he wants to. He's used that power during the investigation. Is that correct?
That's correct. And the other thing that was confusing to me is that the investigation carried on for a while as additional episodes were looked into, episodes involving the president. And so my question is, or was, why were those investigated if at the end of the day you weren't going to reach a decision on them?
So did you consult Deputy Attorney General Rosenstein about the obstruction matter?
Constantly, yeah.
So was he in agreement with your decision not to proceed forward?
Yes. I'm sorry, the agreement what?
Not to proceed forward with obstruction.
Right.
Okay. So very quickly, give us your reasoning why you think it would be inappropriate to proceed forward on obstruction of justice in this case.
Well, generally speaking, an obstruction case typically has two aspects to it. One, there's usually an underlying criminality.
Let's stop right there.
Yeah.
Was there an underlying crime here?
No.
So usually there is.
Usually. But it's not necessary, but the typical case, sort of the paradigmatic case is there's an underlying crime, and then the person implicated or people implicated are concerned about that criminality being discovered, take an inherently malignant act, as the Supreme Court has said, to obstruct that investigation,
so
such as destroying documents.
That people were worried about, that he fired Comey to stop the Russian investigation. That's one of the concerns people had. Let me tell you a little bit about Comey. I do not have confidence in him, Comey, any longer. That was Chuck Schumer, November the 2nd, 2016. I think he, Comey, should take a hard look at what he has done, and I think it would not be a bad thing for the American people if he did step down Bernie Sanders January the 15th, 2017. The president ought to fire Comey immediately, and he ought to initiate an investigation. That is Congressman Nadler, November the 14th, 2016.
All you crazy liberals.
Did you have a problem with the way Comey handled the Clinton email investigation?
Yes, I said so at the time.
Okay. So, given the fact that a lot of people Comey should be fired, did you find that to be a persuasive act of obstructing justice?
No. I think even the report at the end of the day came to the conclusion, if you read the analysis, that a reason that loomed large there for his termination was his refusal to tell the public what he was privately telling the president, which was that the president was not under investigation.
As to where we go forward, as to how we go forward, would you recommend that this committee and every other committee of Congress do our best to harden our infrastructure against future Russian attacks?
Absolutely, yes.
Do you think Russia is still up to it?
Yes.
Do you think other countries may get involved in our elections in 2020?
Yes.
So you would support Congress working with the administration to harden our electoral infrastructure?
Yes.
Is that one of the takeaways of the Mueller report?
Yes.
Do you share my concerns about the FISA warrant process?
Yes.
Do you share my concerns about the counterintelligence investigation, how it was opened and why it was opened?
Yes.
The
Do you
secret
share my
courts.
concerns that the lack of professionalism in the Clinton email investigation is something we should all look at?
Yes.
Do you expect to change your mind about the bottom line conclusions of the Mueller report?
No.
Do you know Bob Mueller?
Yes.
Do you trust him?
Yes.
How long have you known him?
30 years roughly.
You think he had the time he needed?
Yes.
You think he had the money he needed?
Yes.
You think he had the resources he needed?
Yes.
Oh,
Do you think he did a thorough job?
Yes, and I think he feels he did a thorough job and had adequate evidence to make the calls.
Do you think the president's campaign in 2016 was thoroughly looked at in terms of whether or not they colluded with the Russians?
Yes.
And the answer is no, according to Bob Mueller.
That's right.
He couldn't decide about obstruction. You did. Is that correct?
That's right.
You feel good about your decision?
Absolutely.
Thank you very much.
oh God.
Chairman, Mr. Attorney General, the special counsel's report describes how the president directed White House counsel Don McGahn to fire special counsel Mueller and later told McGahn to write a letter, quote, for our records, end quote, stating that the president had not ordered him to fire Mueller. The report also recounts how the president made repeated efforts to get McGahn to change his story. Knowing that McGahn believed the president's version of events was false, the special counsel found, and I quote, substantial evidence, end quote, that the president tried to change McGahn's account in order to prevent further scrutiny of the president towards the investigation. Special counsel also found that McGahn is a credible witness with no motive to lie or exaggerate given the position he held in the White House. Here's the question. Does existing law prohibit efforts to get a witness to lie, to say something the witness believes is false?
Yes.
And,
Lie to the government, yes.
and what law is that?
Obstruction statutes.
The obstruction statute. And you don't have it, I guess, before you.
Well, I'm not sure which one they were referring to here. It was probably 1512C2.
So these things, in effect, constitute obstruction.
Well, you're talking in general terms. You're not talking.
What I'm talking about specifically, yes, you're correct in a sense that the special counsel in his report found substantial evidence that the president tried to change McGahn's account in order to prevent, and this is a quote, further scrutiny of the president toward the investigation, end quote. The special counsel also found McGahn is a credible witness with no motive to lie or exaggerate. So what I'm asking you then, is that a credible charge under the obstruction statute?
We felt that McGahn, the president gave McGahn an instruction. McGahn's version of that is quite clear, and each time he gave it, which is that the instruction said, go to Rosenstein, raise the issue of conflict of interest, and Mueller has to go because of this conflict of interest. So there's no question that whatever instruction was giving McGahn had to do with Mueller's conflict of interest. Now, the president later said that what he meant was that the conflict of interest should be raised with Rosenstein, but the decision should be left with Rosenstein. On the other end of the spectrum, it appears that McGahn felt it was more directive and that the president was essentially saying, push Rosenstein to invoke a conflict of interest to push Mueller out. Wherever it fell on that spectrum of interest, the New York Times story was very different. The New York Times story said flat out that the president directed the firing of Mueller. He told McGahn, fire Mueller. Now, there's something very different between firing a special counsel outright, which suggests ending the investigation, and having a special counsel removed for conflict, which suggests that you're going to have another special counsel. So the fact is that even under McGahn's, and then as the report says and recognizes, there is evidence the president truly felt that the Times article was inaccurate and he wanted McGahn to correct it. So we believe that it would be impossible for the government to establish beyond a reasonable doubt that the president understood that he was instructing McGahn to say something false, because it wasn't necessarily false. Moreover, McGahn had weeks before already given testimony to the special counsel, and the president was aware of that. And as the report indicates, it could that he was primarily concerned about press reports and making it clear that he never outright did the firing of Mueller. So in terms of the request to ask McGahn to memorialize that fact, we do not think in this case that the government could show corrupt intent beyond a reasonable doubt.
Just to finish this, but you still have a situation where a president essentially tries to change the lawyer's account in order to prevent further criticism of himself.
Well, that's not a crime.
So you can, in this situation, instruct someone to lie?
No, it has to be, well, to be obstruction of justice, the lie has to be tied to impairing the evidence in a particular proceeding. McGahn had already given his evidence, and I think it would be plausible that the purpose of McGahn memorializing what the president was asking was to make the record that the president never directed him to fire. And there is a distinction between saying to someone, go fire Mueller, and saying, have him removed based on conflict.
And what would
they have different results.
What would that conflict be?
Well, the difference between them is if you remove someone for a conflict of interest, then there'd be presumably another person appointed.
Yeah, but wouldn't you have to have it in this kind of situation, an identifiable conflict that made sense, or else doesn't it just become a fabrication?
Well, now we're going to shift from the issue of writing the memo or somehow putting out a release later on, and the issue of the actual direction to McGahn. So the question on the direction to McGahn has a number of different levels to it. And first, as a matter of law, I think the department's position would be that the president can direct the termination or the replacement of a special counsel. And as a matter of law, the obstruction statute does not reach that conduct.
Kaboom.
Putting that aside, the next question would be, even if it reached the conduct, could you here establish corrupt intent beyond a reasonable doubt? What makes this case very interesting is that when you take away the fact that there were no underlying criminal conduct, and you take away the fact that there was no inherently malign obstructive act, that is, the president was carrying out his constitutional duties, the question is, what is the impact of taking away the underlying crime? It's not, as the report suggests, that one impact is, well, we have to find some other reason why the president would obstruct the investigation. But there's another impact, which is, if the president is being falsely accused, which the evidence now suggests that the accusations against him were false, and he knew they were false, and he felt that this investigation was unfair, propelled by his political opponents, and was hampering his ability to govern, that is not a corrupt motive for replacing an independent counsel. So that's another reason that we would say that the government would have difficulty proving this beyond a reasonable doubt.
My time is up. Thank you.
Senator Grass.
Kaboom.
Senator Johnson and I wrote you about text messages between Peter Strzok and Lisa Page that appear to show the FBI may have tried to use counterintelligence briefings for the Trump transition team as intelligence gathering operations. I hope you will commit to answering the letter in writing, but also providing committees the requested briefing. That's my question.
Yes, Senator.
Have you already tasked any staff to look into whether spying by the FBI and other agencies on the Trump campaign was properly predicated? And can Congress expect a formal report on your findings?
Yes, I do have people in the department helping me review the activities over the summer of 2016.
I suppose it depends on what conclusions you come to, but is there any reason why Congress wouldn't be briefed on your conclusions?
It's a little early for me to commit completely, but I envision some kind of reporting at the end of this.
The Clinton campaign and the Democrat National Committee hired Fusion GPS to do opposition research against candidate Trump. Fusion GPS then hired Christopher Steele, former British intelligence officer, to compile what we all know as the Steele dossier that reportedly used Russian government sources for information. The Steele dossier was central to the now debunked collusion narrative. Now, here's the irony. The Mueller report spent millions investigating and found no collusion between Trump campaign and Russia. But the Democrats paid for a document created by a foreign national with reported foreign government sources. Not Trump, but the Democrats. That's the definition of collusion. Despite the central status of the Steele dossier to the collusion narrative, the Mueller report failed to analyze whether the dossier was filled with disinformation to mislead U.S. intelligence agencies and the FBI. My question, Mueller spent over 2 years, $30 million investigating Russian interference in the election. In order for a full accounting of Russian interference attempts, shouldn't the special counsel have considered on whether the Steele dossier was part of a Russian disinformation and interference campaign?
I don't, Special Counsel Mueller has put out his report, and I have not yet had anyone go through the full scope of his investigation to determine whether he did address or look at all into those issues. One of the things I'm doing in my review is to try to assemble all the existing information out there about it, not only from Hill investigations and the OIG, but also to see what the special counsel looked into. So I really couldn't say what he actually looked into.
But you think, in other words, if you had looked at all that information right now, you're telling me you could have said yes or no to my question?
If I had looked at it.
Yeah. And you're going to
Yes.
attempt to find
Yes.
some of this information if
Yes.
it's available.
Yes.
Similarly, shouldn't the special counsel have looked into the origins of the FBI's investigation into alleged collusion between the Trump campaign and Russia?
The origins of that narrative.
Yes.
I don't know if he viewed his charter that broadly, and I don't know whether he did or not. That's something that I am reviewing, and again, we'll look at whatever the special counsel has developed on that.
Yeah. In volume 2 of the report, the special counsel declined to make a traditional prosecutorial decision. Instead, the special counsel laid out 200 or so pages relating to a potential obstruction analysis and then dumped that on your desk. In your press conference, you said that you asked the special counsel whether he would have made a charging decision or recommended charges on obstruction for the Office of Legal Counsel's opinion on charging sitting presidents, and that the special counsel made clear that was not the case. So, Mr. Barr,